Well, it's a great pleasure for me to follow Dieter Grimm, whose writing and help have been invaluable to my own work on freedom of speech and academic freedom and constitutional law over many years. My paper is almost exclusively concerned with English law, though the principles of freedom of expression apply in pretty much the same way to Scotland. I'm only going to touch on the position in Ireland, also a common law country, towards the end of this paper, because Ireland, the Republic of Ireland, that is, has constitutional guarantees of freedom of expression, and that might make a difference to the scope and effective protection of the freedom in the two jurisdictions. I think, and this is a point which has been made by other speakers, that it's very important to see freedom of expression in the context of a constitution, or in the United Kingdom, we have to talk about our constitutional arrangements. It should never be divorced from an appreciation of a country's constitution or constitutional arrangements. And for us, that's reflected in the fact that since 1689, the Bill of Rights of that year, freedom of speech in Parliament has been absolutely protected. And that remains an important legal provision. Moreover, the media and other individuals may, as it were, capitalize on that when they report parliamentary proceedings, because those reports are subject to an absolute privilege from any proceedings for particularly for defamation. The United Kingdom has an historical constitution or set of arrangements. And for that reason, I'm going to, my paper tackles freedom of expression in the United Kingdom in an historical way. It takes an historical approach. First of all, let's have a look briefly at the common law before the radical change effected in the UK through the incorporation of the European Convention on Human Rights and Fundamental Freedoms by the Human Rights Act of 1998. The traditional common law, that's case law, decisions of the courts, the traditional common law principles are these. Everyone is free to say or write, to communicate whatever you like, provided there is no legal interference. And of course, there are a number of legal restrictions, some of them old common law restrictions through the offences of sedition and blasphemy, and some of them imposed by statute, typically, for example, the obscene publications legislation. But this means, and this remains an important point in the common law, that freedom of speech or expression, I don't incidentally think there's any significant distinction between speech and expression. Freedom of speech is a residual freedom. It's what we have when the law has run out. And it's also necessarily a negative liberty, because positive rights can only, in my view, be formulated by statute or by constitutional courts. There are traditionally one or two exceptions, and I've discussed this briefly in the paper, where the courts have recognized freedom of speech as a principle of the common law. And just I'll mention one of them, the principle of open justice, the rights that everyone has a right of access to attend courts, including, of course, the media, and the media have a right to report legal proceedings. Those are both aspects of what is known as the open justice principle formulated by the House of Lords in a case, quite an old case, 1916, Scott against Scott. Incidentally, our top court now is the Supreme Court, but up until 2009, it was the House of Lords. After the war, post-1950, the courts began to articulate a freedom of speech almost as a legal principle, so that it invoked freedom of speech as a reason for not developing common law restrictions on exercise of the freedom, and also to interpret legislation. For example, in an old House of Lords case in the 1960s, it was held that insulting in public order and legislation should not be treated as synonymous with offensive or irritating. But the high watermark, the most significant purely common law decision, is the Derbyshire County Council case. I discussed this in the paper, in which the House of Lords held in 1993 that at common law, a public authority could not bring defamation proceedings, totally forbidden, and it followed American case law and a South African case rather than rely on the European Convention. Our law changed in principle relatively radically in 1998, when the Human Rights Act was enacted, incorporating the Convention rights into UK law. I say something in the paper about the principles formulated by the Human Rights Act. I'll just mention very briefly two. First, all legislation must be given effect in conformity with the principles of the of the European Convention, including, of course, freedom of expression. And secondly, public authorities, which include courts, must act in conformity with human rights, the fundamental rights in the Convention. That has had, in principle, an enormous impact on the developments in the last 20-odd years of our laws of libel and privacy. Since 2000, when the Human Rights Act came into force, the courts have developed in a number of cases principles of freedom of expression after the Human Rights Act. This is by far the longest section of my paper, and I'll just summarize some of those principles very briefly before talking about one case in a little detail. First of all, the courts in England do not distinguish between purely political speech and other speech of public interest or concern. What they do is distinguish between public interest speech entitled to a high degree of protection and gossip about celebrities, pictures of celebrities, pornography, and in most cases commercial speech, which is entitled to a lower level of protection when balanced against competing private rights to reputation, privacy, and the public interest. Indeed, in one or two cases, the House of Lords gave rather low level of protection to speech at an election context. And I discussed the pro-life alliance case when the House of Lords, by a majority, refused to allow an anti-abortion political party to show pictures of aborted fetuses in their election broadcast. I think that's the worst decision of the courts in the last 30 years on freedom of expression. The one case I want to discuss in detail is the famous Animal Defenders International case. In that case, the House of Lords unanimously upheld a comprehensive ban on political advertising on television and radio. It rejected a challenge by an animal rights organization to protest in a television advert against cruelty to animals. This has a number of important features. One, unusually, commercial advertising has a higher degree of protection than political speech in this context. There may be good reasons for that, but it is an interesting point. Secondly, the House of Lords declined to follow, and I think this is the only case in which this has happened, a European court ruling, the Barendt gegen Tierfabriken case against Switzerland, which it distinguished. The third point raises an interesting question about the relationship of freedom of speech or expression and democratic debate. The reason for this ban was, of course, to stop richer pressure groups and well-endowed political parties buying up more airtime than could be afforded by smaller parties or pressure groups. So the House of Lords said, yes, that's a good reason, and it justifies the total comprehensive ban on all political advertising. And Lady Hale, who subsequently became president of our Supreme Court, encapsulated this argument very succinctly when she said that freedom of expression must be balanced against voter equality. The last point I'd make about this case is this. The House of Lords was reluctant to question a parliamentary enactment and the decision of the government to proceed with the bill, the Communications Bill 2003, even though it knew that it wasn't sure it would satisfy the requirements of the convention. And it's an interesting example, and there are others, of how the courts often defer in England, and I'm sure in other countries, to the judgment or assessment of the political branches of government. I'll come back to that point briefly at the end. Freedom of expression has also been important in the understanding and the construction, application of legislation restricting freedom of expression. Sometimes this happens at the political or parliamentary level. Legislation is drafted more restrictively to incorporate or to reflect the value of freedom of expression. So, for example, the incitement to religious hate speech is defined more narrowly than the old racial hatred prohibition. I do wonder, and this is explored in a couple of pages in my paper, whether the courts have always honoured their obligation properly to apply legislation compatibly with the requirements of the convention. Too often, it seems to me, they're reluctant to question the findings of lower courts, their assessment of the facts about what speech is insulting. Final question before I move to the last part of the paper. Has the Human Rights Act made any difference? Has it significantly strengthened the contribution that freedom of expression can make to public debate? I doubt whether it has actually affected the disposition of any cases or significantly widened the scope of effective freedom of expression. I think it has affected at most the approach the courts take to deciding cases. And there has, interestingly, and I mentioned this in a page of the paper, has been a revival in a few cases of let's start with the common law. Let's not worry too much about the convention until we see what the common law approach to the case is. The last part of the paper explores the difference between the common law and constitutional rights to freedom of expression. One of our more liberal, radical judges, Lord Steyn, was inclined to say in one or two cases that freedom of expression is now a constitutional right in the United Kingdom. Myself, I think this is judicial rhetoric. It does not have higher normative force. The courts cannot, unlike the United States Supreme Court or the Bundesverfassungsgericht, invalidate legislation. It can only declare it incompatible with the convention, and then it's for Parliament to act to remedy the infringement. We've discussed in some of the papers this morning whether courts could impose duties on government or an authority to respect an effective freedom of expression, to recognize positive rights rather than a bare liberty to freedom of expression. In Ireland, it's possible this could be done. And in one broadcasting case, one Irish judge said, admittedly, by the way, obiter, that he thought the law could compel public broadcasters to show serious programs relevant to the conduct of an election. I think it's inconceivable that an English court would interfere in this way. And I say this for two reasons. First of all, the tradition of the common law, as I said at the outset, is that freedom of expression is a residual negative liberty. We're free to say anything we like when the law doesn't step in. But we don't have any claim rights, to use the Hofeldian distinction, a positive claim right against Parliament or government to compel it to honour or respect or promote effective freedom of expression. So I think that's one reason. The other reason is this: there is still a judicial reluctance, quite unlike that in the United States, or Professor Grimm might have more to say on this, sometimes in Germany. There is a traditional reluctance to question the judgment of the political branches of government. That was shown in the Pro-Life Alliance case, in the Animal Defenders case, and more recently by our new Supreme Court in a recent case in which, by a majority, the Supreme Court refused to invalidate a ban imposed by the Home Secretary on the entry into the UK of an prominent dissident Iranian to address a meeting of MPs and peers in the Houses of Parliament. That was a clear infringement of freedom of expression, but the Supreme Court refused to question the judgment of the Home Secretary that it was necessary to refuse the dissident entry in the interests of national security. So I think for those two reasons, the courts will be unlikely to play any role in strengthening effective protection of freedom of expression and recognizing positive rights to speak. The effective protection of freedom of expression in the United Kingdom remains as much a matter for the political branches of government as it is for the courts. I regard that as a sad final observation with which to conclude my presentation, but thank you very much for listening to me.